My name is Alamin Salvarajo, and I'm a third-year legal studies student at Ontario Tech University. My presentation is titled Originalism versus Purposivism, an Interpretivist approach on Dobbs v. Jackson Women's Health Organization. In this presentation, I'll examine Dobbs through an interpretivist approach, outlining the material facts, the decision, and the majority's reasoning. I'll then proceed to construct a purpositivist argument showing how this approach better aligns with the 14th Amendment Due Process Clause, eliminating the narrow and exclusionary nature of the term liberty produced by originalism. The reason why I chose an interpretivist approach is that this case was built on constitutional interpretation, where the majority focused on the historical and linguistics factors rather than the broader human issue at hand. So let's look at the material facts of Dobbs v. Jackson Women's Health Organization. The case began when the state of Mississippi passed the Gestational Age Act, which prohibited abortions after 15 weeks of pregnancy, except in cases of medical emergency or severe fetal abnormality. The respondent, Jackson Women's Health Organization, which is the only abortion clinic left in Mississippi, challenged this act, arguing that it violated existing legal precedents such as Roe v. Wade and Planned Parenthood v. Casey, where both Roe and Casey established that abortion is a constitutionally protected medical procedure. The district court ruled in favor of Jackson Women's Health Organization, striking down the act as unconstitutional. And the state of Mississippi appealed the matter to the Fifth Circuit Court of Appeals, which later upheld the district court's decision. Then the state of Mississippi appealed to the Supreme Court of the United States. So what was the ruling of the Supreme Court of the United States? Well, the Supreme Court of the United States reversed the lower court's ruling and ruled in favor of the state of Mississippi, whereby the U.S. Constitution does not protect the right of abortion. In doing so, the court overruled two landmark precedents, such as Roe v. Wade and Planned Parenthood v. Casey, whereas aforementioned, these cases had previously recognized abortion as a constitutionally protected right pursuant to the 14th Amendment Liberty Clause. So the Dobbs decision declared that the Constitution does not protect the right to abortion, and as a result, the states, which are the elected state representatives, have been granted the authority to regulate or to prohibit abortion. So what made the Supreme Court lead to that decision? Meaning, what was the majority's reasoning in this case? Well, the ratio decidendi of the majority was delivered by Justice Samuel Alito, and his colleagues and himself ruled on the following reasons. Reason number one, the majority found that there is no express reference or provision in the U.S. Constitution regarding abortion. In other words, because the Constitution does not explicitly mention the word abortion, the majority concluded that it cannot be recognized as a constitutional right. So they looked at the linguistics aspect of the Constitution. The second reason was that they found that the 14th Amendment Due Process Clause does not afford the right to abortion because abortion was widely criminalized across the states in 1868, which is the same year when the amendment, the 14th Amendment, was ratified. And so they looked at the historical aspect of the 14th Amendment Due Process Clause and said that, well, given the fact that it was widely criminalized in the time of the ratification, it does not afford the right to abortion. And so based on these 2 points, which are the linguistics and the historical aspects of it, the court subsequently declared Roe v. Wade and Planned Parenthood were erred rulings. And so it cannot be preserved under the legal doctrine of the stare decisis. In essence, they cannot be used as legal precedents because the Supreme Court found that these were erred rulings because they interpreted and they applied the 14th Amendment Due Process Clause in an incorrect way. And so, given that abortion is not constitutionally protected, It is now a matter of the states to regulate or to prohibit abortion, meaning the power is now vested to the states to determine whether abortion should be legal or not on a state by state basis. So, before I present my argument, it is important to understand what originalism is. According to Sirota 2021, and I quote, originalism is based on two ideas. One, the meaning of the constitutional text was fixed at the time each provision was framed and ratified. And two, courts and officials should be bound by that fixed meaning. So, by this direct quote from Sirota 2021, she further conceptualized this interpretivist approach called originalism by dividing it by two principles. One is the fixation thesis. So, the meaning of the Constitution is to be determined by the linguistics and historical context of the time of the enactment. And the constraint principle, that is part of originalism, stipulates that judicial interpretation is constrained and bound by that fixed meaning. And that fixed meaning is that fixation thesis. And so, by these two key principles, they produce what is called originalism. So, these are the two key elements that produces originalism. So, to what extent did the majority opinion develop an originalist interpretation of constitutional law? Well, in the case of Dobbs, the majority reasoning clearly reflects the principles of originalism, particularly the fixation thesis and the constraint principle, as I've mentioned in the previous slide. So what I have done is extracted the direct quotes from the judgment of the majority in order to assess whether or not there's a strong application of originalism. So the first quote is referring to the 14th Amendment Due Process Clause. And so the majority wrote the following, and I quote, that provision has been held to guarantee some rights that are not mentioned in the Constitution. But any such right must be deeply rooted in this nation's history and tradition. Close quotes. So this strongly correlates and aligns with the fixation thesis, as I mentioned in the previous slide, where the meaning of the Constitution is determined by the linguistics and historical context at the time of the enactment. Moving on to the second point, the second quote, and I open quote, guided by the history and tradition that map the essential components of the nation's concept of ordered liberty, the court finds the 14th Amendment clearly does not protect the right to an abortion. Close quotes. So this closely aligns with not only the fixation thesis, but as well as the constraint principle, as they locked into the historical and linguistics aspect of it, and they were very restrictive on changing the 14th Amendment. And so they said that, well, the court finds the 14th Amendment does not protect the right to abortion. That's it. And then lastly, and I open quotes, Roe was rigorously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And so this aligns with the constraint thesis because it's constraining Roe from developing an assertion that, hey, abortion should be included under the 14th Amendment's Due Process Clause. And so that correlates with the the constraint thesis, because it has that restrictive element to it. And so by these direct quotes, and these are the key reasonings of the judgment, it's clearly evident that there's strong findings and applications of originalist interpretation. So the Dobbs decision revealed several key shortcomings of originalism as an interpretive approach. As Binney 2007 describes, originalism produces frozen rights because it hinders the constitutional growth and adaptation of constitutional principles that would reflect today's society. And secondly, the decision demonstrates how originalism turns judges into servants of the past, of colonial judges, rather than guardians of the Constitution, right? They're not ensuring that or upholding that principles evolve with society. They're just enabling the ideologies of colonial judges and interpreting in today's society. And so this would subsequently threaten democracy, right? Originalism interpretation of constitutional law can threaten democracy and equality, as it confines and restricts the understanding of liberty to a historical context that could exclude marginalized groups and today's norms. So, a powerful president to reaffirm these points is the Persons case, as Binney 2007 noted, where the Supreme Court of Canada once held that women were not qualified persons. But through purposivism and the living tree doctrine, which I'll get into later, it enabled the Constitution to grow and then to adapt to gender equality and to receive justice. And that was not through originalism, it was through purposivism. In contrast to originalism is purposivism. So what is purposivism? Well, purposivism focuses on interpreting a right based on why it exists and the interest it was meant to protect. So rather than confining the interpretation based on historical or linguistics contexts, purposivism looks at the broader picture, such as what is the intended purpose of this right to serve. And so, by this notion, it ensures that the Constitution reflects today's society rather than the society that was a long time ago. And so, this leads to the living tree principle. According to Binney 2007, purposivism is basically like a living tree. The idea that the Constitution must grow and adapt like a tree rather than being fixed like originalism. So now that we have a solid understanding of what purposivism is, I'm going to now introduce my argument, which takes a purposive approach to interpreting the applicability of the 14th Amendment Due Process Clause to the facts in Dobbs. So the 14th Amendment Due Process Clause is the following. No state shall deprive any person of life, liberty, or property without due process of law. And so when we take an originalism approach, it would strictly say that abortion is not protected under liberty because abortion was criminalized when the amendment was enacted in 1868. So it looks at the history of it as well as the linguistics of it, because the Constitution does not expressly state that abortion is a constitutional right. And so by this originalism interpretation, it maintains and upholds history and linguistics. But if we take the purposivism approach, which I support and argue for, a purposivism approach looks at the broader picture. It looks at not just linguistics and history, but it looks at conversation of bodily autonomy. It looks into a person's dignity and equality rights. And so with the purposivism approach, it would entertain the notion that abortion is protected under the liberty provision pursuant to the 14th Amendment Due Process Clause. Right? It would open arms to, you know what, abortion should be protected under the 14th Amendment. And so by this, it maintains and upholds a person's bodily autonomy, a person's dignity, and equality for all persons, instead of just maintaining and upholding history and linguistics like a museum. And so by purposivism approach, it also considers science and expertise in judicial reasoning. This was from Gash 2022, where the paper said that with an originalist approach, it's very limited on history and linguistics, but when we take a purposivism approach, it considers science, it considers expertise, it considers actual factual evidence. And so I would like to end this off with my argument by Binney 2007 from the Honorable Justice Binney, and I quote, "Our Constitution should be interpreted in light of our experience as a country." And so by this quote, it says that constitution must accommodate and adopt to the growth within society, not to be restrictive and say, no, we must follow the norms and the ideologies and notions of 18th century. It says we have to grow as a society. We have to learn from our experiences as a country. So now I'm going to conclude on the significance of my argument, why I think relitigating Dobbs v. Jackson Women's Health Organization matters. It's no surprise that Dobbs v. Jackson Women's Health Organization has confined the meaning of liberty to the norms of the 18th century. But this is a very alarming legal precedent. It's a very pressing issue. Because if we were to confine liberty, our laws won't progress. And if our laws won't progress, then society won't progress. Our society and laws would be fixed and static. But if we were to adapt the purposivism interpretation, we can grow as a society. It enables us to the pursuit of justice and equality for all. As we saw in the Persons case, where the Supreme Court of Canada held that women were not qualified persons. But through the purposivism interpretation, women were to be qualified persons. And so, going to my next point, by relitigating Dobbs v. Jackson, it helps restore a person's bodily autonomy, dignity, and equality. Because by relitigating Dobbs v. Jackson with a purposivism approach, it would interpret that liberty constitutes as the right to abortion as well. And so this restores a person's bodily autonomy, because a person would have the right to choose an abortion. And this restores dignity, because that person would have that bodily autonomy right. And it restores equality, because it's not dependent on states. It's all states would conform with the Constitution. And so this strengthens the Constitution's legitimacy. Because if the Constitution is seen as a legal document that reaffirms the 18th century norms, then people lose trust within the Constitution. The Constitution won't be a sacred legal document. Rather, it would be a frowned upon legal document. And so Gash 2022 makes a really good point that if we don't relitigate Dobbs, vulnerable pregnant individuals would be in a high exposure risk of criminalization. Because if there is a state that says abortion is unlawful and that individual doesn't qualify for an abortion, it could lead to criminality. And this doesn't only threat the matter of abortion, but this judgment poses a threat to 2S LGBTQ plus rights and other liberties grounded in bodily autonomy. Because the rationality, the ratio decidendi behind the ruling stated that the 18th century norms and the meaning of liberty is to be confirmed. It's supposed to be as followed. We can't change it and we can't interpret it. So you can imagine the amount of threat that it poses towards 2S LGBTQ plus rights and other liberties grounded in bodily autonomy.